Hi, folks. I'm Greg McLawson, the Affidavit of Support lawyer. I help folks enforce the Affidavit of Support in federal actions, federal district court actions, and I serve as a consulting expert when the Affidavit of Support is being enforced in family law proceedings. I wanted to talk today about an issue that comes up really too often. It's an unfortunate one. And that's the question of whether an immigrant is endangering their immigration status if they choose to enforce the affidavit of support. The bottom line is no. The sponsor has no authority to instigate deportation proceedings against the sponsored immigrant. And in fact, it's probably the sponsor who's engaged in misconduct if they even make a threat to endanger the immigration status of a plaintiff enforcing the affidavit of support. So just as a reminder, under the affidavit of support, a sponsor promises to provide any income that's necessary to ensure that the sponsored immigrant has income equal to 125% of the federal poverty guideline. That's roughly $1,400 per month for a household of one in 2022. If the sponsored immigrant has income below that level, they have the legal ability to sue the sponsor for support. They can do that in state or federal court. Now, this affidavit of support is signed in virtually all family-based immigration matters. However, it's typically a spousal situation where this ends up getting support enforced. So a situation where you have a U.S. Husband or wife who has signed a petition and signed an affidavit of support for their foreign national spouse. So very often it's either in the context of a divorce that the affidavit of support is raised or a divorce has just been finalized. It's often the case as well that the sponsored immigrant is on a 2-year conditional residency card. Anybody in that situation understands that's a tenuous and uncertain legal situation to be in, because that green card holder in the 90-day period before their 2-year card expires has to file the I-751 removal of conditions petition. So that's the petition that's customarily filed with the U.S. citizen spouse. Obviously, if you're going through a divorce, you may not have the cooperation of the U.S. citizen spouse, in which case the I-751 can be filed as a waiver. But very often, to begin with, that sponsored immigrant is in a uncertain immigration situation. They have their 2-year card and they're worried about being able to successfully transition to that 10-year residency card. So it's often very much first and foremost in the mind of the sponsored immigrant. If I go after that I-864 sponsor for financial support, is that going to endanger my immigration status? Okay, so first of all, let's set aside the issue of the I-751 petition. That petition does need to be filed in a timely manner. So that's again at the 2-year anniversary of the person's 2-year conditional residency green card. Now, you can actually file it past that 2-year date if you're filing as what's called a waiver application, which is filing it by yourself just as the immigrant. But you do need to get that 751 petition in. The 751 petition can be filed on the basis of a good faith marriage that was dissolved, which is to say, ended in divorce. So assuming that the marriage was bona fide to begin with, the sponsored immigrant can most certainly proceed with the removal of conditions process without the participation of the U.S. citizen spouse. So that's one thing. But what my clients in the affidavit of support enforcement context tend to be more worried about is if they go after the sponsor for financial support, can the sponsor, quote, report them to immigration? So let's dive into that one. Well, first of all, yeah, of course, the sponsor is able to communicate to immigration. So here we're talking about USCIS or ICE, Immigrations and Customs Enforcement. And realistically, you're not going to be able to stop the sponsor from shooting off whatever letter they want to send to the immigration agency. It is often the case that when an affidavit of support case is initiated, the sponsor will take basically any action they think they possibly can to get out from under the liability of the affidavit of support. And that includes sending off angry emails to USCIS. Let me say, though, that in all of the cases I have done enforcing the affidavit of support, I have never once seen that sort of angry email from a sponsor result in any sort of investigation of one of my affidavit of support clients. Now, why would that be? The way that I think about it is if I am in the fraud division of USCIS and I see that a marriage has fallen apart and a US citizen is mad about the way that things worked out, I probably see a lot of those sort of angry letters from US citizen petitioners all the time. And I'm going to be really skeptical that what has happened in that case is actual immigration fraud versus a marriage that didn't work out and people who are mad on both sides, which is sad and unfortunate, and also just the way the world works sometimes. So my guess is that when the fraud division sees these letters, if they see them at all, they're viewed with a very high degree of skepticism. Because remember, when it comes to a marriage underlying the immigration process, the legal question isn't ever whether it was going to be a good marriage and whether the parties made a good decision by entering into it. The question is whether it was bona fide and in good faith. So the fact that a marriage doesn't work out a couple of years down the line and the parties get separated really doesn't have any bearing on whether there was fraud to begin with. In addition to this, it's quite worth noting that allegations of fraud are just completely irrelevant to the merits of a case to enforce the affidavit of support. We have litigated this issue here in Washington State, in California, and elsewhere. There was a recent decision by the 11th Circuit Court of Appeals, and federal courts have conclusively held that affidavit of support sponsors may not avoid liability under the affidavit of support merely by arguing that a marriage wasn't entered into in good faith. The reason for that is that the statute under the affidavit of support doesn't permit that defense. The statute allows for only 5 terminating events that end a sponsor's obligation under the affidavit. This includes when the sponsored immigrant becomes a citizen or has 40 quarters of work. But there's nothing in the immigration statute that allows the sponsor to avoid liability based on playing Monday morning quarterback about whether the marriage was in good faith. I'm guessing that probably one of the reasons we have that consistent holding from federal courts is that federal courts do not want to wade into the messy world of domestic relations matters. And they certainly don't want to be sitting in judgment, again, as a Monday morning quarterback over whether a marriage was entered into in good faith years prior. But in any event, allegations of fraud federal courts hold are simply not a defense to affidavit of support liability. So, like I was saying, it's very unlikely that an allegation made by a sponsor is going to lead even to an investigation. But let's go one step further. Unfortunately, it's often the case that it's not just the sponsor who makes this sort of allegation of fraud, but their attorney. Now you've got a different situation altogether because attorneys are beholden to the rules of professional conduct. And one of the things you can't do under the rules of professional conduct, this is more clear in some states and others. California has very clear rules. Washington has rules that are better than some. As an attorney, you can't try to secure a strategic advantage in a case by threatening the immigration status of a defendant. And that's something, unfortunately, that we've seen happen 2 times in particular I can think of in California, where the defense attorney on the other side of one of these affidavit of support cases wanted to say, hey, if you proceed with this case, we are going to report your client as having committed fraud to the immigration agency. In one of those, we pointed out to the defense attorney that that was impermissible. He ended up withdrawing from the case. In the other, It was actually the judge who raised the issue and said, look, you can't try to secure an advantage for your client, the defendant, by trying to threaten the immigration status of the plaintiff. The judge in that case was quite angry and referred that attorney to the State Bar Association for potential prosecution. And the judge even mentioned that making that sort of threat could potentially constitute the crime of blackmail. So this is really quite a big deal. Note that while individual sponsors are not bound by the rules of professional conduct that apply to attorneys, that idea of blackmail would. So depending on the nature of the threat, if you have a situation where an affidavit of support sponsor is saying, look, if you, the plaintiff, push forward with this civil claim, I am going to try to get you booted out of the United States, that's potentially a blackmail situation. So the stakes are very high. It's very clearly impermissible, and also it's just going to be ineffective. But probably, if you are a sponsored immigrant and you're considering bringing a case of this nature, probably the best assurance I can give you is to say that even though the threats are impermissible and shouldn't be made, it is often the case that it happens, but that is typically without consequence. So again, in all of the cases that I've litigated under the affidavit of support, I've seen a lot of these threats from affidavit of support sponsors. I know because we've seen the letters that they have sent angry, mean emails and letters to the immigration agencies saying that their spouse never loved them and it was all fraud. And again, I have never seen that result in any form of investigation against one of my clients. So it's unlikely that if someone were to press a case under the affidavit of support, that the sponsor would have any ability to instigate an investigation. And maybe the final thing to leave it on is this. If you are the beneficiary of an affidavit of support and you know that you entered into a genuine relationship and you know that the marriage fell apart for reasons that didn't have anything to do with bad intentions going into it, you don't have anything to worry about. You are the one who's most familiar with the facts of your relationship. If you know that you didn't engage in anything improper to get a green card, you should have nothing to worry about. And in fact, it is the sponsor who should be worried. If the sponsor signed an affidavit of support for your benefit and they are not providing the financial support that they are responsible for, it's the sponsor who's not living up to their legal obligations. And you, as the sponsored immigrant, have a right to recover financial support from that sponsor. And you shouldn't be shy about doing it. You should be comfortable standing up for the rights that you're entitled to. And it's the sponsor who needs to be worried. If you have any questions about enforcement of the affidavit of support or about the fraud reporting questions we've raised here, feel free to drop them in the comments and I will answer them to the best of my ability. Have a great week, everybody, and take care.